Good afternoon, everyone. Thank you very much for coming, either virtually or in person, to this next session on an international perspective on supporting judges at a global scale. I have a surprise announcement, and it's a good one, which is that we have a surprise guest panelist, and that is Mr. Scott Carlson. He is the executive director in charge of the American Bar Association's Center for Global Programs, and he has more than 25 years of experience in designing, managing, and evaluating anti-corruption, human rights, rule of law, and democracy and governance programs around the world. Over the course of his career, which is quite distinguished, he has worked in numerous countries. I'm just going to list a few, ranging from Afghanistan and Albania and Bosnia through to Serbia, Tanzania, Tunisia, Ukraine, of course the US, Uzbekistan, and more, including over 6 years of overseas work, field work. Prior to his return to the American Bar Association in 2020, Mr. Carlson worked at the US Department of State, the US Sentencing Commission, the UN, USIP, and Chemonics International. He has advised governments and analyzed the justice sector in a variety of contexts. His expertise has been applied to the formal education of judges and lawyers on international standards, utilization of these standards in multiple national courts, and the adoption of new technology to encourage and safeguard the rights of litigants. For example, a national video system in Kazakhstan. Furthermore, Mr. Carlson's legal expertise has been tested in various international fora, including serving as Deputy Legal Advisor for Human Rights, the International Commission on Kosovo, litigating successfully at the European Court of Human Rights, and representing the US government at the UN Access to Justice Working Group, which led to the adoption of certain resolutions, namely the United Nations Principles and Guidelines on Access to Legal Aid in Criminal Justice Systems. He graduated with honors in law from Georgetown University, has an LLM in International and Comparative Law, and the University of Georgia JD. And interest of full disclosure, I have known him for many years. We both worked in the early days on legal reform efforts in the former Soviet bloc. And then we will hear from Mr. Prateek Sibal, and he'll be beaming in from Paris because he works at UNESCO. He is a program specialist at the Digital Transformation System of the Communication and Information Sector at UNESCO. In this framework, he coordinates the sector's work on artificial intelligence and digital transformation with a focus on capacity building for the judiciary and government. His work spans research, advocacy, policy advice, and capacity building for governance of digital technology. So our discussion will talk about the intersection of assisting judicial systems and the latest technological developments, particularly with respect to AI, but allow me to turn it over to Scott. Thank you. I suggest you use the mic.
Thank you, Alan. All right, let's see if I'm up for the challenge here on my PowerPoint. I thought this was touchscreen. Well, good afternoon, everyone. It's a real pleasure to be here. I want to thank AAAS for this invitation. Alain left out one part. The American Bar Association and AAAS have a storied history of collaboration, particularly in this sphere, but it has been some years since we have been in close collaboration, and I look forward to hopefully this being the jumping off point for future collaboration, or let us say a renewal of our past. I must say also in preface that while I am with the American Bar Association, all the views that I express are solely those of my own, given that we have a sole spokesperson policy, which is the ABA president. So the unit within the American Bar Association that I run is called the Center for Global Programs. And the American Bar Association, you may or may not know, I want to give you a little bit of background so you understand the perspective I'm coming from. We're a membership organization, but we have multiple subdivisions within that membership organization. And so we have member-driven sections, like some of you may be familiar with the international law section. And those are guided by the members themselves, and people are elected to those positions. Then we also have professional units, and that's what the Center for Global Programs consists of, which are specialized technical units that are run and staffed by professional staff. And in this case, the Center for Global Programs, the one I'm in charge of, administers grants and contracts in the international development space, and it has three subunits within it. The first is the Rule of Law Initiative, which many of you may have heard of. The second is the Center for Human Rights, and the third is our UN Representative Office that basically staffs any meetings at the UN where ABA members and staff may have interests. Now let's talk a little bit about the ABA Rule of Law Initiative, which is the primary unit under my jurisdiction. It used to be called the Central European and Eurasian Law Initiative, and in fact that's when I got my start with the ABA, which is almost now 30 years ago. And I was a pro bono volunteer in the Republic of Albania in the 94-95 time period. And we started with the fall of the Berlin Wall with this great outreach of American lawyers offering pro bono assistance to these countries emerging from behind the Iron Curtain. Now, over the course of many years, we expanded beyond Central and Eastern Europe and the former Soviet Union, hence the change in the name from CELI, as you can see the acronym on the slide, to ROLI, or the Rule of Law Initiative. Today, ROLI does a lot of work in the legal reform space, working to strengthen legal institutions, of course, support legal professionals. We are the American Bar Association after all, and so we tend to work with bar associations elsewhere in the world. But we also focus on fostering human rights and advancing the public understanding of law and citizens' rights. We do this work through a whole network of in-country collaborators. They can be government institutions, they can be civil society experts, professionals, as well as just common citizens. One of our defining sort of rubrics is that it's not the American way or the highway. We're there to offer comparative expertise. So we let the programs and the way they are designed and they unfold be driven by the local actors and the particular needs that they have in that jurisdiction. So for me, rule of law is sort of an innate concept, but for some of you in this room, I know we have a diverse audience, and online, there might be some, pause when you hear the phrase rule of law. What I've got up on the screen, and I share as a definition that now is about 20 years old that the United Nations came out with. And I'll just read the first sentence because I think it really does capture the essence of rule of law. Rule of law is a principle of governance in which all persons, institutions, and entities, public and private, including the state itself, are accountable to laws that are publicly promulgated, equally enforced, and independently adjudicated, and which are consistent with international human rights norms and standards. Yes, that's a mouthful, but it was intended to be all-encompassing. And this definition is one which we have adopted internally for our own purposes, and the State Department and the U.S. Agency for International Development also employ this as well. So that's sort of the scene setting on how big, what are the, I would say, borders of the type of work we do at the Rule of Law Initiative. So why is this important? Why have I left the normal practice of law and devoted the last, 30 years to this? Well, these statistics are a little bit out of date, a couple years out of date, but they were assembled by the World Justice Project and the Task Force on Justice, or Pathfinders for short. And a couple of years ago, 2/3 of the 7.7 billion people on the planet at that time lacked meaningful access to justice. And what do we mean by that? Well, 1 billion just simply lacked legal identity. That means they don't have driver's license, they don't have a passport, they are basically not inside the formal economy. 2 billion, in fact, are employed in the informal sector. And so they, too, are detached from the formal institutions and processes. Then, not surprisingly, you find that many people lack proof of land or housing ownership. Again, when you have that many people outside the formal legal sector, that follows logically. Then there are people who are in extreme justice conditions, and by that, even though slavery has been abolished for many years, there's the equivalent of 40 million people who are in essence subjected to modern-day slavery. 12 million are stateless. That means there is no country in which they could even begin to apply for legal identity and appropriate paperwork. And then, and I think this number has gone up quite a bit in the last 2 years, there's at least 200 million people that live in places that are so insecure that it's impossible to seek justice in any meaningful way. So at the end of the fiscal year, and our fiscal year closed on August 31st, we had approximately 100 different programs in over 60 countries. And this map and this list of countries gives you a sense of the range of geography that we currently cover at the Center for Global Programs. In approximately a third of those countries, a significant chunk of our work focuses on judicial reform. And I'll talk a good bit more about that in a second. So what are some of the tools and approaches that we typically consider when we approach judicial reform? So I've identified a couple that I think are pretty significant for us, and one I'm going to look into a bit more in detail in a second, is a Judicial Reform Index, which we designed in-house at the American Bar Association about 20 years ago, and we've run this index in a number of countries. The next is a political economy analysis, which is sort of the tool du jour at the U.S. Agency for International Development, which looks at the relationship of institutions and actors. Where does the real power lie? Who might promote reform or block reform? And then I also want to linger on a new paradigm, which is called people-centered justice. That group that helped produce those statistics, Pathfinders, issued a Justice for All report in 2019, which you can Google and pull up online easily, which lit this whole discussion. And I will also linger on what do we mean by people-centered justice in just a minute. There's two other subsequent publications which I think are kind of fundamental and might be interesting to this group. The one is the OECD Framework and Good Practice Principles for People-Centered Justice. That's 2021. And then the U.S. Agency for International Development, their new rule of law policy just came out in the last months, in spring of this year, also focusing on people-centered justice. So I want to run through this Judicial Reform Index real quickly to show you the range of factors that we look at when we show up and try to work with partners to think about where they might have needs for further reform programs. There's 30 factors, and I'll just go through them rather quickly. Of course, in the Q&A we can dig in on anything that you wish. So the first of these tranche here examines the composition and preparation of judicial personnel. It's looking at how they're trained and what the diverse blend of people are within that, what sort of appointment process and continuing legal education available. The second bucket looks at judicial powers. These are powers that the courts themselves own and can use. And you can see judicial review of legislation, appellate review, contempt, subpoena enforcement, et cetera. The second tranche here looks at financial resources. So what percentage of the state budget is available for the judiciary to use? Is that adequate salaries, which is, of course, a very important factor when thinking about corruption, because in many countries, judges are paid so poorly that simply to survive, they, on occasion, do take the bribe. And then, of course, judicial security. Then there are structural safeguards, and these are ones that protect judges against political interference or manipulation. Guaranteed tenure is an obvious one that most countries employ. But there's also questions about what are the removal and discipline processes for judges, how are cases assigned, how are judges represented, et cetera. The fifth bucket is accountability and transparency concerns. And these are ones that are really important to, and this is a debate in our country right now, how the people perceive the judiciary to be operating. What are the rules of the game? Is there an enforceable code of ethics? Do the public and media have access to proceedings? Are all judicial decisions published? You'd be shocked to know how many countries around the world don't publish their judicial decisions. And then the last is just sort of the support structure that makes all this possible. Admin staff, case filing and tracking systems, distribution and indexing of law. Can you just, if you have new laws, how easily can you find out what the latest is and how it applies? So the last thing I wanted to sort of throw out in terms of the big panoply of concepts and things to discuss is this new idea of people-centered justice. And here I'm focusing, this graphic is stolen from the U.S. Agency for International Development. But I think it hits and it gives you a good visual about what they're trying to do with this new paradigm. And this new paradigm is designed to sort of, when I started 30 years ago, it was all about changing constitutions and sort of that big picture, getting the scaffolding together. And it was sort of, I think, the field of dreams fallacy, build it and they will come. Well, we built some of that scaffolding and no one showed up in many cases. And so people began to say, well, why is that? And they took many lessons from trends in the software industry, which, in the late 80s, early 90s, there was this switch to user-centered design. And so people in the legal space started reading about that and what does it take to get people comfortable to approach and use the justice system. And so, to really grossly simplify what this new policy with USAID does, it seeks to demystify rule of law. I always say to people, if rule of law is just the province of lawyers, we've lost the game. And I say that as a lawyer. But rule of law has to be owned and utilized by all citizens and residents in society. The other thing about this new policy is it focuses on the nuts and bolts of how justice is delivered. What's the user experience when they approach a courthouse? Do they know what room they're in? Did they get adequate notice of when a hearing would be held? This, to answer things like that, you need data. And the other thing this policy does is it focuses on getting the right data about the user experience as they approach the courthouse. Now, I've just talked about courts, et cetera, but a people-centered justice approach applies in various sectors. So, for example, using this lens about thinking where do systems intersect with society and does that interface work to allow justice to be provided, think about a farmer who has an irrigation rights issue. Does that farmer know where they can go? If someone builds a dam upstream, what is the, I would say, pathway or runway that they have to seek justice? And so this, by looking at the interface of system, society, and services, you find some interesting answers to questions like that, and it goes across all sectors. So with that, hopefully I've provoked some thought here in the audience and online, and I will look forward to the discussion.
Over to you, Prateek.
So thanks for the invitation, Alan. Glad to be here. And also, thanks for the presentation, Scott. I think there are a lot of synergies between what we are trying to do at UNESCO on rule of law as part of our Judges Initiative and what you presented as part of the work that AAAS ROLI initiative is doing. So I'll walk us through a bit about what UNESCO is and how it works before we dive into the specifics of our Judges Initiative. So UNESCO, as an intergovernmental organization with 194 member states, which recently welcomed the United States back in its fold, and we are very happy about it, works through basically 5 functions, which is around awareness raising. So if we take the example of artificial intelligence, for instance, when we started talking about this technology in the policy circles, mostly in around 2016, 2017, UNESCO started to identify the good practices, the challenges emerging in different parts of the world, kind of convened the different actors and tried to understand what are the challenges, how is this technology evolving, what kind of governance frameworks do we need. And based on this kind of a global overview, UNESCO was able to develop standards. So this is our standard setting function where we develop principles and values to guide the future development of AI. Once we develop standards, member states ask us how do we translate those standards into national policy frameworks. So here comes our role on policy advice. Once we advise them, there is, of course, the question of implementation of those policies, and hence we work with member states on capacity building. And finally, our role as to facilitate international cooperation with different organizations, between governments and countries and different stakeholders. So this is what UNESCO or different parts of UNESCO would do. Some would do all these functions, some would do some of these functions. Now, coming to the Judges Initiative, we've been working with the judiciary at UNESCO for about 10 years now and have engaged about 35,000 judicial actors. When I say judicial actors, judges, lawyers, prosecutors, civil servants and legal administrations in over 160 countries. And we have primarily worked through MOUs with different regional, national, human rights courts and Supreme Courts, and have over this 10 years developed a lot of training content, not only in the form of about 11 massive open online courses, which have been dealing with issues related to freedom of expression, access to information, safety of journalists, and most recently on AI and the rule of law. And we constantly produce guidelines for judges, prosecutors, whether it's on data protection and privacy, or the ones that we will develop soon on generative AI. The goal is really to reinforce capacities within the judicial systems on international and regional standards related to human rights. And this we do through on-the-ground trainings, training of trainers workshops, as well as these online courses. Some of the lessons that we've learned while working with partners in different parts of the world is that strong partnerships with regional human rights courts and local networks are really key to some of the work and some of the potential impact that we can have. For instance, when we talk about freedom of expression, UNESCO has been working with the ECOWAS Court of Justice, the East African Court, the African Court on Human and People's Rights, the Inter-American Court, and some of the judgments have also started to reflect the international standards on human rights more closely. Then we also work with the national judicial training institutions, where the objective is also to strengthen their capacities to deal with some of these issues and to potentially update their training curricula. And we, of course, leverage the regional trainings to then kind of reach to at the national level. So, for instance, we'll be organizing soon a training in Costa Rica with the Inter-American Court of Human Rights on artificial intelligence, and where the objective is to have judicial operators, trainers, and judges from about 17 countries to work with us. As I mentioned, we have partnerships with not only courts, but also associations of prosecutors in different parts of the world as well. Now, coming back to artificial intelligence. So we've been working, as I mentioned, since 2014 on freedom of expression, access to information, safety of journalists. But around 2018, we started to see there is interest in AI. And we launched a survey to our network of judicial operators. And we were able to reach about 1,200 judicial operators in about 100 countries. And they expressed two needs. First, that they want to learn how judiciary itself can use AI systems to simplify and improve administrative processes, because as a lot of you in the room would recognize that it's a problem across the world where there are judges are overworked and understaffed the courtrooms. So there's a strong incentive to look at how AI can be used to improve their lives and administrative processes. And the second concern was, of course, around what are the broader legal and human rights implications of AI, whether it comes to facial recognition systems being used in public spaces, or biometric identification systems and their impact on privacy and data protection. So we bring in all these issues, and the first product in this domain that we actually launched is a MOOC on AI and the rule of law that I'll talk a little bit more. But for those in the audiences, a quick kind of primer on what is AI. It's really machines imitating or mimicking human intelligence. And this is really based on data that they are trained on, algorithms that parse through this data and produce decisions. And then there are different forms of AI, and machine learning is one, and then there are deep learning and so on. And generative AI is another form. Just as a quick example, in the judiciary, AI can be used for e-discovery and document review, for predictive analytics and decision-making support, and there are a lot of examples in the US on that. For language recognition and analytics, for instance, we see a lot of demand for this when it comes to transcription of courtroom proceedings. This is a kind of a low-hanging use of AI, which aids the decision-making process quite a bit in courts. Then AI systems are being used in dispute resolution, in risk assessment, and of course, management of case files and so on. Coming to our work at UNESCO, more on artificial intelligence and the rule of law, we've developed our first product as the MOOC on AI and the rule of law, which was actually launched with the National Judicial College in the United States and a host of other partners. This course really looks at what are the opportunities, the risks, and is kind of a cautionary tale also on AI, while also emphasizing that there are a lot of good use cases, and we bring in these use cases from different parts of the world. But let me probably share a short video of this course.
As AI systems are deployed across the world, their use is raising important questions related to protection and promotion of human rights and fundamental freedoms. How are judicial operators affected in their quest to uphold the rule of law in the age of AI?
What are the implications for human rights?
How can AI be adopted to improve the administration of justice?
UNESCO's Judges Initiative is at the forefront of engaging judicial systems on the protection of human rights, both online and offline. This MOOC on AI and the rule of law is a 6-module introductory course developed by UNESCO and the Future Society, bringing together a lineup of diverse subject matter experts from around the globe.
We will discuss the digitalization of justice systems and the rise of online courts.
We will also explore the implications of the use of AI on human rights with respect to questions of bias, discrimination, privacy, and freedom of expression.
Throughout the course, we will touch on examples of AI use across different justice systems and the emerging jurisprudence in the domain. We aim to have a participative dialogue and promote knowledge exchange to help you build capacities to effectively address AI issues across justice systems.
Join the debate
And enjoy our lectures.
Well, I hope you could listen to the audio because I couldn't, but So yeah, so this course is also available free for everyone in 7 languages. So in case any one of you is interested, please feel free to register and take the course. It's a global program that we are having, and as I mentioned, there were participants in this course from about 140 countries and about 4,500 people, judicial operators, enrolled for the course. And the lecturers were also very diverse, which kind of brought in unique perspectives from different regions, because we're still at this stage where there's a lot of learning to be done from different parts of the world. And then there's just some examples of some in-person trainings that we've been doing with the judiciary in Qatar, in Tanzania, in the Gambia, and so on. Finally, some of the upcoming tools that we have as part of this program. So we have a training toolkit on AI and the rule of law, which is really a 4-module curriculum for the judiciary. And this is something that we hope could reach institutions, because the MOOC is a way to reach individuals directly. And through our next product, we want to reach institutions and strengthen capacities in the long term. A lot has happened with respect to AI over the past few months. We had this famous ruling in the United States around lawyers using ChatGPT and so on. So we are also going to be launching an advanced MOOC on AI and the rule of law. And we are also working now on guidelines on generative AI for the judiciary, which would first be based on a survey of our community of judicial operators worldwide, and to learn a little bit more about the practices with respect to Gen AI that they are how they are using Gen AI. And then we will be developing and launching these guidelines sometime towards the end of the year. So happy to engage in the conversation forward, and thanks so much. Back to you, Alan.
All right. I seem to have. Let's see. We seem to have the reverb. Prateek, could you perhaps mute yourself on the other end for just a second, please? See if that helps with the reverb. Okay. No, there we go again. But you can hear me, correct? Good. I'm going to take the moderator's privilege and see if I can ask a question, forgive me for the reverb, that hopefully links a number of things together. So if I understand correctly, Development Goal 16 of the United Nations is directed towards trying to increase access to justice for all, to put it very simply and crudely. So there are 2 questions. One is, to what extent does the SDG 16 inform the work of both the ABA and UNESCO in this general area? And number 2, if we're all moving towards a more people-centric approach to justice, trying to help that, how does AI potentially help, and how does AI potentially undermine that? Because obviously, if you've got a machine that is helping people make decisions, even if these might be slightly minor things, like traffic accident cases or something like that aren't too bad. On the one hand, it might facilitate access by a person to some form of legal assistance, right? And may make certain kinds of decision making more efficient. But how does that interface with a more people-centric approach to justice? Let me start with Prateek, if I may. Thank you. Take two.
Hello, can you hear me now? Okay, perfect. So yes, so everything that we are working on relates to the SDGs, and in this case with SDG 16, specifically on access to justice. So let me give you some examples, and then also take in the questions around opportunities and risks related to AI with that. When I was talking about transcription and making judicial systems more accessible, and this was also, I think, one of the points in the slides from Scott around people-centric justice. So the idea here is, again, if you can make use AI to make judicial processes and systems first quicker, then justice delayed is not any longer like kind of, there is no justice delayed and justice denied scenario. Second, we can reach people in their own languages, simplify some of the concepts. That really helps. We have seen cases where a lot of people in various parts of the world are not so familiar with the legal terms and terminologies, and there can be AI systems which can help simplify some of these processes, break them down by different stages. So this really makes judicial systems also more people-centric. These are just two examples. One, how it can make things faster. Two, how it can make things more accessible. Having said that, there are also challenges just in terms of internet connectivity. So it doesn't mean that AI is a panacea for all problems. We have issues with respect to broadband connectivity. And this was particularly visible in times of COVID, when a lot of countries moved to some forms of virtual courts, but in a lot of cases, this was not possible. Second, now coming to the risks and how AI can actually disadvantage a lot of people, is if the AI systems used in courts are biased, are built on data sets which are not representative. And this can lead to systemic exclusion of some people. And we know of some of the examples in the US, for instance, the Compass system, and there are a host of other systems being used for predicting risks of reoffending and so on. And these remain challenges. But at the same time, I must say that AI systems are really mirroring the biases that we see in society. And they are showing those biases to us. And now it is our role to try to address those biases and also make AI systems more inclusive and fair. So I'll stop there, Alan.
Thank you.
Well, I'll just add real quickly, we're very invested in Goal 16. We were delighted when it came out. And the group I mentioned, Pathfinders, really is devoted to making sure that 16.3 really do have a life. And that's a multilateral organization that has some civil society organizations like ours, but also a number of nation states. And so we're 100% behind that. In terms of AI, we, of course, are studying that. In fact, I was talking with Alain, and we're coming up with our first guidance in-house. It's supposed to be at my desk, I think, when I get back. And so I'm looking forward to seeing that. There's a lot of issues. I think Prateek covered a number of them, so I won't repeat those. But
Thank you very much. I believe I'm being told that we have to wrap things up, but we have one question from the floor. Allison, go ahead, please, if your floor mic works. Let me hit the floor mic thing.
Hello, I'm Allison Rentelm from USC in Los Angeles. Thank you for both of you. I'm wondering how you determine what courses judges would most like to have, and if you're going to use the online platform for other kinds of subjects. And I'm wondering what languages, how you mentioned the ability of AI to help with that. Will you be taking courses you've already established to put them in other languages? So I was curious about that. And I was also curious about on access for people with disabilities, whether you're using assistive technology. So I'd like to learn more, but I better stop.
Thanks for that question. So how do we learn from on what subjects to work with? First, we have some bit of mandate from our member states, but importantly, we engage with the community of judicial operators that we work with. So as I mentioned, we did a survey first and tried to understand from them what are their needs and then try to address them. We also recognize sometimes that it's not possible to develop a MOOC because that takes a lot of time, investment. So we also engage when it came to new issues, for instance, on generative AI and intellectual property, or on AI-generated evidence in courts, and how do we understand that? How are courts dealing with this? What is the academic thinking on that? and also on augmented and virtual reality use in courts. So we do treat some of these topics also through webinars that we do with the community, which is a more dynamic platform to get feedback, as well as keeping the community engaged. Now, in terms of the languages, the MOOC that on AI and the rule of law, we made it available in 7 languages, which are 6 UN languages plus Portuguese. It's of course quite costly to do that and make all the readings, the platform, everything available in so many languages. But the response was great. As we've also seen, people are much more comfortable learning about these learning in their own languages. We have unfortunately not really dealt with how to reach out to persons with disabilities through our content yet, but that is a good point, and I will take it back, and we would definitely try to work on it. Yeah, thank you.
Thank you both. Any last comments, either Scott or Prateek, and then we'll wrap it up, and thank you.
So I hope this has been stimulating for everyone here today. On that last question, we do a lot of coursework, but it's all customized locally with our local counterparts, usually a judicial training center. And they frequently survey judges and also have new legislation as priorities. But we also try to introduce new concepts like what we're talking about today with artificial intelligence into those conversations.
Thanks. Prateek, any last thought?
Thanks. No, I think it was fantastic, and happy to also continue engaging with the community here and also with the ABA, potentially including on the surveys and the tools that we are developing. So thank you so much. Yeah.
Thank you all, online and in person. Thank you.